Good morning, Your Honors. William Shellhart, Office of the Attorney General, appearing on behalf of the appellant, the state of Florida. Your Honors, we are here today because the state of Florida. I apologize, Your Honor. I'm not used to being the appellant. Yes, 5 minutes for a rebuttal, please. We believe that the trial court erred in 3 respects in granting the motion to suppress. First, the trial court did not afford great deference to the issuing magistrate. Instead, she conducted a de novo review of the probable cause affidavit. Second point, we believe her de novo review of the probable cause affidavit was incorrect because instead of applying a totality of the circumstances approach, she looked at each bit of information in the affidavit piecemeal and dissected it then.
Let's get to the chase.
Yes,
so
sir.
to speak. Where is the nexus in this case? Pointing the home to allow, you're taking the position that the court should not have allowed, came to the conclusion there's no nexus. You're taking an issue with that regarding the search of the home. Where is the nexus?
As contained in the search warrant affidavit, it is setting up the hand-to-hand transaction, having surveillance on Mr. Stfler's home, observing Mr. Stfler exit.
Nobody can say what was in the home, right? The whole interior of the home, like for example, in our Castro case or our Sherry case, why don't those cover this situation?
I'm sorry, Your Honor, I didn't follow the question.
There's no mention in the affidavit of what was found inside the home. Right?
That's correct. The affidavit says he does sell controlled substances, he does sell guns, and that the guns are kept in the home. There is no specific mention.
No verification of what's in the home, I guess is what I'm trying to say.
Yes,
Which is a lot like the Castro versus Florida case. That's what I was trying to get you to respond to. 224 Southern 3rd 281. Why isn't our case covered by what in Castro?
I think Castro is factually different, as I pointed out in my brief. I believe, if I'm remembering Castro, it's the 2 separate addresses where he receives the MDMA at one address, picks it up, goes to a second address, law enforcement then applies for a search warrant of that second address, and this court said, no, there's no nexus there. Here, we do have Mr. Stfler directly exiting the Burroward home address, going directly to the hand-to-hand location.
Well, there's something in between. There was a passenger in the car, right?
Yes.
So we don't know whether or not there was speculative. He could have gotten the drugs from him. He could have gotten. The key here, what was the connection to the home? And I think, forget the pun, I think that he jumped the gun. If they would have waited, would have had more information. Anyone to say, I've been inside the home. This is the transaction that occurred in the home, which would justify the granting the search warrant in the home. That would establish the nexus. But here, what you have based on this record is the guy coming out of his house. There's the passenger in the car. There's the hand-to-hand transaction later on. Why is the judge wrong in denying your request?
Because, and I made the argument that the judge's analysis of it's possible that Mr. Stfler retrieved the drugs from the Nissan Pathfinder or retrieved them from Mr. Martinez. That's possible. Is it probable? No, I think it's more probable to believe that because you had this anonymous tip that says Mr. Stfler is selling drugs, that you had surveillance on him exiting his home, going to the hand-to-hand location, that it's probable that he kept those drugs in the home.
This was just saying there's no corroboration about the nexus to the home. That's the key. In the home, you have this statement saying the CI says this is in the home, but where's that corroboration in this record?
I think the hand-to-hand transaction.
But you have an intermediate step. I had a problem with that. He didn't leave his house and go to make the hand-to-hand. He left his house, got into another vehicle, driven by another individual. That's like big elephant here. You want to ignore that.
I don't want to ignore it. I just want to differentiate the differences between possibilities and probabilities. Probability is a fluid concept, that there is no bright line test, that we look at whether it's probable that something is in the location. I think given the fact that Mr. Stfler was named as the seller of controlled substance, it wasn't Mr. Martinez. The anonymous tip didn't say that, oh, Mr. Stfler sells oxys and methamphetamine and marijuana, and he gets his supply from Mr. Martinez, who delivers them to him in a Nissan Pathfinder. Then I think you deal with information where it reduces the probability that those drugs came from Mr. Stfler's home. You don't have that here. You have someone, an anonymous tipster, who is able to provide his name, date of birth, phone number, street name. Those items are corroborated by law enforcement. They set up the surveillance. They do a cold text to him. They're able to arrange a hand-to-hand transaction for 10 oxycontin for a pre-recorded buy funds, and they're able to observe Mr. Stfler retrieve those items from his pocket. He didn't retrieve them from the glove box. He didn't retrieve them from Mr. Martinez. He retrieved them from his persons. Is it possible that Mr. Martinez gave him the drugs, or that he retrieved them from somewhere inside that? Yes, it's possible. It's not probable. If I buy a lottery ticket, it's possible that I win. It's not probable that I'm going to win. So I think probable cause is a fluid concept. We have to look at the totality of the circumstances. Yes, the anonymous tip itself would not have been sufficient.
Sir, in this case, the warrant and affidavit were devoid of proximate cause to support the assertion that drugs or guns were in the residence. Nothing there that would corroborate that. There's nothing there. What's wrong with that statement?
I believe the court ignores, again, if you look at the anonymous tip, that's not enough. If you dissect the totality of the statements in the search warrant affidavit, that they had this surveillance, that they were able to send a cold text, that they were able to get Mr. Stfler to agree to an exchange of drugs for money. And then even afterwards, that Mr. Stfler said, yes, I can do more of this. I have more oxy, I have more meth, I have more molly, that we can continue to engage in future transactions. I think if you look at it in the totality of the circumstances, it's very probable that Mr. Stfler had drugs at his home.
You do know, based on our constitution, I mean, that going in somebody's home, staying to stay.
Yeah.
So the state could have just waited a little bit. That another transaction, maybe directly from the house, it would have solved all this.
And again, probable cause, I keep saying it's a fluid concept. There is no bright line test. You don't have to do 3 hand-to-hand transactions and observe the suspect removed from his home and go to the buy location on 3 separate occasions, as the court cited the Nichols case in its order. There is no bright line test. We deal with probabilities. Yes, could there have been more probable cause? Yes, I think that's the case in any case. You can always develop more probable cause. The question is, when is there enough probable cause to support the issuance of the search warrant? And I think if we look here, if we look at the steps that the reviewing court, the trial court in this instance should have taken, she did not afford great deference to the issuing magistrate. She made no finding that the issuing magistrate abused his discretion in doing it. Her de novo review of the search warrant affidavit did not appreciate the totality of the circumstances. It looked at it in a piecemeal analysis. And then the court refused to apply the good faith exception. Here, even if we get to the good faith exception, which I don't believe this court has to, but even if we get there, this probable cause affidavit is not so bare bones or containing conclusory statements that officers relying on it had no good faith belief that they would not have found controlled substances in this residence. So it was objectively reasonable for law enforcement, what a county court judge issues the search warrant, for them to rely on it. The purpose of the exclusionary rule is to deter bad police conduct. It's not to punish police who go and get a search warrant. A sitting county court judge signs that search warrant and then they go execute it. That doesn't do anything. So if we...
You're absolutely correct as what you said. But it goes down to one of the basic things where there's a lack of corroboration on one aspect of the home that's contained in the search warrant that you want the trial court to follow. That's the problem. If it's all corroborated, you're absolutely correct. But there's that lack of corroboration, which would really is important to establish the nexus. That, I think, is the problem with this case.
So if I believe I'm understanding the court's argument or position in this, is that
Statement based
Statement.
on this.
statement based on this record, I apologize.
No problem.
The state does not see a problem that Mr. Martinez and his Nissan Pathfinder were involved in this. I understand that it is an intervening circumstance, as pointed out by Judge LaRose here, but it does not defeat probable cause. It's not probable to believe that they had the name, they had his date of birth, his phone number, his address. They said
That could be easily found. Regrettably, right now on the internet, you could get all that information.
but then they were able to set up a hand-to-hand drug transaction with him.
Correct, with the intervening that Judge Rose mentioned, that's there. So put that in the equation in terms of the facts. And I think the bottom line is you can't just simply look at this myopically. You have to look where it's the nexus, and that I think is the crux of this case. And I apologize that I peppered you, and I want to be able to give you the opportunity to
No,
present.
I guess it's just the state's position that and again, I hate calling it an intervening circumstance. This isn't a situation where police lost sight of Mr. Stfler from the time he exited his home to the point of the hand-to-hand transaction as has defeated probable cause in other cases. I believe the state has a problem with finding that because a drug dealer gets a ride from someone else to a hand-to-hand location, that's enough to defeat probable cause or the nexus requirement. When officers observe that drug dealer exit his home, the target search area, and proceed directly to the hand-to-hand transaction. I think that sets a dangerous precedent. And for those reasons, I'm asking this court to afford the issuing magistrate that great deference and find that there was probable cause for issuance of the search warrant. Thank you.
Thank you, Mr. Shellhart. Mr. Joseph?
Yes. In the case, court. Mark Joseph on behalf of Eves near St. Fleur. Your Honor, I believe that that the court is correct in that the nexus is not there in this case. We have a situation where we had an anonymous tip, but this anonymous tip did not say that there was drugs in the home. The anonymous tip did not say that the drugs were being sold out of the home. And it gave bare bones information, basic information about selling drugs. And they said that there was guns that were being sold out of home, but the police were not able to corroborate that information at all. Because there was no evidence of him selling out of the home. If there was a situation where undercovers or some type of informant went to the home, bought drugs at the home, then we'd have a totally separate situation here. But this is a situation where they called him, they arranged a deal, he went to the location. But as the court has pointed out, the big issue here is that when he left the home, he entered someone else's vehicle as a passenger, went to the sales site, and then was selling drugs there. But there's no.
Let's back up a minute, Mr. Joseph. What do you say in response to Mr. Shellhart's position that the trial court give due deference to the issuing magistrate's decision? You would agree that deference is required.
Yeah, it is required. However, in this case, the probable cause was so lacking based on the facts of the case that when the magistrate should have seen that there was absolutely no nexus in this case for that affidavit. And even the police officers who wrote this affidavit, they should have seen that there was no nexus as well. Just because a person exits their house and does a drug deal, they're ignoring the fact that there was a passenger, that he was a passenger in a car with another individual in the car. That we have no indication here that the drugs came out of the home. They could have come out of the car. They could have come from the driver of the car, Mr. Martinez. That is not taken into account. And so even the magistrate or the law enforcement officers should have seen that, that there was no nexus, no indication that there were even drugs in the home. This was something where there was just mere speculation that there were drugs in the home. Even the anonymous tip did not say that the drugs were coming from the house. And because we have to look at the four corners of the affidavit, not any other additional evidence, we see that there is no corroboration. We see that there is no nexus. So there cannot be probable cause in this case.
Okay,
That's why.
thank you. Mr. Shellhart,
Yes, Your Honor. I don't think I'm going to take all full 5 minutes.
all right, you got them if you need them.
I just want to reiterate, it is the state of Florida's position that a drug dealer getting a ride to the hand-to-hand transaction does not defeat the probable cause, does not defeat the nexus. After officers set up the drug deal with the drug dealer, they observe him exit his home and go to the buy location. And if there are no further questions, I would ask this court to reverse the trial court's order. Thank you.
Thank you, sir. Thank you both.
Thank you.